the fact that the rudimentary depiction of the security plan changes the testimony of the community that occurred on March 1st. And based on that, this board found that there was no public need and accommodation for the transfer of this license to 2610. And the fact is, based on the 2 ex parte letters to the board reversed and said now there is a public need.
And we'll be happy in our decision phase to explain what we mean by all that. The judge has asked us to explain that, and we'll get our chance to explain it. I just want to hear from you first.
Am I allowed to put witnesses on?
It depends on the purpose. I mean, proffer the testimony. Obviously, it's not for the security plan, because I've asked you already if you want to have somebody testify about the security plan.
I would like, well, is it going to be given weight if the church owner comes up and says that they do not authorize you to allow the applicant to put the security plan into the file or install these cameras? Does that have any relevance?
Yeah, I mean, we already did rule on that a few minutes ago.
And, okay. And Mr. Kadensky, you said earlier that the community.
I said, not, you say the community, I don't
Okay.
recognize that
Cold
term.
Spring, Homestead, Montebello Community Corporation, you said, I believe, and please clarify what you said, that they met with your clients and you indicated that based on the fact that there was no MOU signed, and then all of a sudden the community was going to oppose it? You said something like that.
Well, no, I did not meet with I only met with 2 people at this whole big meeting they had. It was Mr. Washington and Mary Pat. No community was there.
Okay, Mr. Washington. Okay, so Mr. Washington of the Community Association is here right now. Mr. Washington would, I know, testify that there's still no public need and accommodation for this, regardless of this security plan. It has no bearing at all on the fact that there are already 5 liquor establishments within a 4-block radius. The fact that they.
Is this duplicative? Is this a duplicative proffer? Or will that be duplicative testimony?
Well, I don't know. I don't know. But the way I'm looking at it, I mean.
It sounds like it would be.
It's surprising that very important facts are not interested.
They have been presented before the board heard those concerns on March 1st.
Oh, on March 22nd, did the board hear the communities?
We heard them in the original hearing. So the question that the chairman asked, will you be providing duplicative testimony? I think the answer is yes. Now, do you have anything outside of those concerns?
Okay, the community was not able to testify on at the March 22nd hearing regarding the security plan. So it will not be duplicative. So I would like to call Mr. Washington, the president of the Community Association, to the stand.
Regarding the security plan.
Regarding the security plan.
We'd like to hear from him.
Thanks.
Thank you, Mr. Washington.
Hi, Happy New Year.
Sorry.
Mr. Washington.
That's okay. Look, this whole issue of a security plan is totally irrelevant to us. The place could be Fort Knox. There still is no need for this establishment when we have so many others in the community. Now, someone would have to refresh my memory going back to the March hearing and provide to me my testimony where I said, hey, if they present a security plan, the community's fine with it, because that was never a condition for us. And I believe at that time, when the issue of a security plan was brought up, I don't think I even responded with an indication that that would be fine for us. So, and I could be wrong, because I don't have the transcript in front of me, but if someone could go back in a transcript and just point out to me, hey, Mr. Washington, you said yes, you would be fine with this security plan, I'd like to just have my memory refreshed.
All right, anything else, Mr. Washington?
Well, once, in regards to it being duplicative in nature, and I'm not an attorney, okay, but I don't have, as a representative of the community corporation, even the right to ask a question of Mr. Pease, which is, to me, something that is germane and valid. Because what is of concern to us is not someone who is going to be, in essence, a front, but whether or not this person who is fronting on the license has even spoken to the needs of the community in person and in face where we've had an opportunity to dialogue. The last thing that I would add is that regardless of what the outcome is here, there's a hearing coming up Thursday over at the War Memorial Plaza that would have some impact
Today, isn't it? Or next
Thursday. And right now, I don't know that we need to rush to this judgment when, going forward, there may be new legislation introduced that would make all this null and void. So, I mean, that's it, unless Mr. Kandinsky has any questions or
I have a
anyone.
question.
Sure.
Mr. Washington, you said that the security cameras are irrelevant to you at this point, correct?
They were on March 1st.
Do you recall your testimony from March 1st, when you stated that in and around that area, which, quote, I refer to as bar murder triangle, unquote, is that a concern of yours, the safety due to the murderous nature of that area?
Well, not only is that a concern of mine, the murderous nature of that area, it's a concern of mine for the murderous nature of that, of the entire city.
Right, but specifically to this address, at 2610 Harford Road, would the security cameras be able to assist in reducing the crime or assist in?
Are you asking my opinion?
Yes, I'm asking you. You
I
mentioned-
don't think that it would make a difference because their testimony was that they already had security cameras up there. Now, the question is whether or not the quantity of the security cameras make a difference. It was also stated that no one ever shared any information regarding any criminal activity with law enforcement. To suggest that there was no criminal activity going on in that area would be in and of itself suspect. So,
Mr. Washington,
okay,
I
I'm
just
sorry.
want to be clear.
Right, yeah.
It's your testimony that additional cameras would not prevent murders, correct?
Absolutely.
Would additional footage of any crime existing in that area be an additional support to our police department who are investigating these crimes?
The police department would have to answer that question.
In your opinion, do you believe that these
No,
live
because the
footages
city-
would- let me finish, Mr. Washington.
Yeah.
Do you, in your opinion, do you believe that any footage caught by these security cameras would be an assistance to the police department?
No. I believe that the cameras that are already hardwired and monitored by the Baltimore City Police Department at its central location and at the district would provide that coverage. In regards to need, putting a security camera up does not, in my opinion, create a need for this establishment. Okay? I mean, if you have 6 bars, or shall we say 6 establishments in a relatively close proximity that have, that sell alcohol, a simple virtue of having a security system does not mean that, okay, now we can increase the number of these establishments in the area because this creates a need. I think the need would be based on whether or not the community is in of itself underserved by liquor establishments.
Thank you. That's Fred.
All right, and Mr. Washington, not to belabor the point, but isn't it a fair assertion that nearly every protestant who testified at the March 1st hearing voiced objections about safety regarding the location?
Oh, absolutely, and I think that that is a big concern. And so, in order to ensure the public safety of Coldstream Homestead Montebello, please rule that this establishment cannot go there. That solves the whole issue.
But didn't everyone who testified regarding objections to the transfer testify regarding loitering out front?
Well, I testified to a number of issues. The most important issue that I testified to was public need, okay? And I believe I went on this useless diatribe, obviously useless, about there not being a need for an additional accommodation of this type in Coldstream Homestead Montebello. But to suggest that the community in and of itself somehow has given its permission by saying, hey, there's so many of these establishments in our neighborhood, there's a ripple effect, health consequences. Hopkins, after we made our initial argument about the ripple effect, Johns Hopkins substantiated what we were saying here at that hearing. Look, If you're really concerned about the public safety of the Coldstream, Homestead, Montebello community, then you will not allow this transfer to go ahead. Any other means that they put up there or take place could be security cameras. It could be them having not only a security camera, but a guard standing outside is not going to meet what we need to have that establishment, to reduce the number of establishments of that type in our community. And so those are two separate issues, okay? And if we want to argue each issue individually, we can. But security is a separate issue, separate from our community need for another establishment of this type.
All right, thank you very much. Any questions for Mr. Washington?
No questions.
Thank you, Mr. Washington. Ms. Hughes, who's next?
I would like to call the pastor of the church, if you're going to let him discuss. Actually, I would like to call the pastor of the church. I believe he will offer testimony about the church, their interest in having the liquor establishment operating in the community, based on the fact that there is a prevalence of alcoholism and a drug problem in the neighborhood.
I'm going to object to that.
I mean, I believe we heard testimony about that almost a year ago, about loiterers, people drinking out front, people engaging in illegal activity, including possible drug dealing out front. I thought we'd already heard about that a year ago.
Well, I'm looking at in the transcript, there were at least 3 community members that didn't address or didn't speak to in their testimony the security plan, security cameras. They spoke to the fact that there's a bus stop there, all the children at the nearby school linger there, the fact that they are trying to heal the community from those woes that are associated with low socioeconomic living, and the fact that the fact that there are so many other liquor establishments in the area, they do not need it. They don't want it, and Mr. Fisher testified, of course, Mr. Washington, and Miss Connie Tolbert, I believe her name is.
All right, yeah, we heard from, and the community thought it was important to bring Mr. Blair Vaughn in here from the CSAFE, from
Yes, sir.
GOCC. And obviously, point of his testimony was safety, isn't that right?
Yes, sir. Well, among other things, I mean, you wrote in your finding that at the end of the day, in this case, based on the testimony, based on Mr. Vaughn's testimony, Mr. Washington's, and Ulysses Fisher, who lives extremely close by, the only evidence we have on the record as to public need and desires from the opposition, and the factors that we have in the evidence here today simply do not indicate any public need or desire for the request, and so it will be denied. So I believe that the community and all the witnesses spoke to all the factors that the board is to look at in their decision under 10202. The public need and desire, the number and location of existing licenses, the commonality or uniqueness of the services and products. Of course, there's none. The impact on the general health, safety, and welfare of the community, including issues relating to crime, traffic, parking, work convenience, and any other necessary factors. But it doesn't say anything in here about security cameras and a security plan. And of course, the fact is, the board did find that it's not necessary for the accommodation of the public. And of course, the community asserts that also the applicant isn't fit, only that the one applicant lives in the county and the other applicant isn't here, and we also say he lives in the county.
That's what you're saying now,
Well,
but that's not what was tested, that wasn't part of this hearing in March.
It doesn't, I would think that this board would want to do ethically and professionally what they're charged with doing, and that is make an investigation into the application and in all aspects. Now, I don't know what fit person to receive the license is, or material false statements when the application doesn't have the correct information. Now, at the March 1st hearing, I think Mr. Gdansky asked the applicant, Ms. Susha Sharma, whether everything in her application was accurate and correct, and she said yes. But it isn't, and we're just,
No, I'm objecting this point more. You keep talking and talking.
that's what I'm here to do, Mr.
No, you're
Gdansky.
supposed to do things
We're hearing
the
from her. We'll
rules.
sustain your objection, though. These issues have, as I've explained, they weren't raised back in March. They weren't made part of the judicial review of this hearing, and therefore they weren't included in the order. There was no specific instruction for us to consider anything regarding the application or the perfunctory basic requirements of this application.
We disagree. I don't see in that order that it says that it's strictly limited to this security camera plan. The judge ruled that the board goes back to March 1st.
Okay.
That's when all that was discussed, and that's what I'm here to discuss.
All right. Is there anything else?
No, there's nothing else.
All right.
Just in closing, and I saw you looking at the transcript. If you just look on page 36, when you're referring, you had asked Mr. Washington whether he discussed the security. There's a whole page about security cameras. I don't know if you saw it or not. That's all, fine.
Yeah, no, we've gone through the transcript.
Nothing further.
All right, we're going to go off the record.
Yep.
Mr. Washington, you want to close?
Well, just before
On the record.
we go off the record, and everything here, I guess, is subject to interpretation. But I don't think, based on what was read back to me from the previous hearing in March, that I gave any indication that the only condition that we had as a requirement was the addition of security cameras.
Well, let me clarify the record. On March 1st, you said, unquote, we've asked for additional security measures, and we've asked that these security measures include video surveillance, unquote. That's
Right.
what you said.
Yeah.
You asked for this.
Not of
We're not
the-
limited to it, but you did ask for security cameras.
Right, yeah, but not of the new people. We asked that of the old owner.
For the building.
No, we asked that from the old operator of the liquor license.
but for that
So hold on a second. So when there's a new element introduced, then we, of course, evaluate that based on the introduction of a new element. So what we requested from the previous licensee of the liquor license does not mean that that automatically goes forward to the new individuals at all. And so if that was the interpretation that I gave or the impression I gave, I apologize, but let me absolutely make it clear that what we had talked about in regards to security was in regards to the previous ownership. But I will acquiesce to that point. That still does not, in the mind of the community which I represent, how we were able to arrive at that conclusion, okay, well, they put cameras up, so now there's a need for this establishment to sell liquor. I still don't see that connection. I still don't see that connection at all. And before we go, if someone could explain to me, with the number of liquor establishments we have in that area, how by simple virtue of them putting up some security cameras, that now creates this tremendous need in Chum for the additional sale of alcohol? Please explain to me how that works.
Thank you very much, Mr. Washington. We're going to go off the record.
He had to. Why is our executive secretary messing with the petitioners?
He does that a lot, though. He runs around and always wants to. These mics. What's 1935?
Harvey's.
So you can hear clearly the way I'm hearing it. Those mics will get Oh, okay, so to make sure they can hear. Yeah, it's just like. So wait, so you're gonna go all the way home and come back out? Yeah, no, it's across the street. Make dinner and cheese. Like you said, it wasn't 30 degrees. I'll take it, man. Because I mean, then I'm the type of guy, man, once I'm in the house, I'm not coming back out, man. It better have been really, dude, it's cold as hell outside today. You either go all the way home, get comfortable in a nice warm house, and then wait till something comes back out freezing cold. Better than that. Takes off. Does it really? I just hope that we don't have. Well, we already had some. Hope we have like last one. It was perfect. It was a little warmer. Didn't have a lot of. I don't think we had like most of that stuff. Sure.
Okay. I think there's still some back there. I guess we're ready.
Why do it for me?
He has a petition.
Their parents. The one that I wanted.
Follow my lead. Which is the only way out of it. Do this right.
I saw you got the testimony that he asked. We heard.
Yeah.
Okay.
All right, I'm ready.
Oh, we're ready. We're ready.
Ready, we're go on the record. January 3rd, 2013, Sushma Sharma and James Peace, Kailash LLC, trading as Dew Liquors, 2610 Harford Road. We're here on remand from the Circuit Court. Review the record, accept some new evidence regarding security plan. Board is reviewed People's Council for Baltimore County versus Country Road Shopping Center, 144 Maryland Ave 580. It appears to be a fit in that we were not told to have a de novo hearing. We were not told to have a full evidentiary hearing, but an evidentiary hearing. And as with the County Board of Appeals for Baltimore County, we, according to the case law, are indeed correct to consider the limiting of the scope to the issues that Judge Murdoch highlighted. And that is the first exhibit of the applicant, which is the security plan. But the judge further, in her oral decision, which we've received in evidence, indicated that we needed to clear up the record. We needed to go through the evidence and support our findings with evidence, substantial evidence from the record. So the first thing we're going to do is we go back and look at the transcript. And it certainly refreshes our recollection. I, as the chair, did state that we're not finding any public need and desire. And that was right after something that Mr. Kudinski said, where he said, nope, we're not gonna sign this agreement, vote it up or down. The board didn't like that, in all honesty. We weren't sure that council was being fair, rejecting an agreement outright. We note for the record that every one of the persons who testified on behalf of the protestants' case, it all came back to the same thing. It all came back to liquor stores are bad. They attract crime. They attract loitering. In some cases, they had children go there after school. All anecdotal evidence, none of which was specifically related to the location, 2610 Harford Road, which had been in existence since 1935. Indeed, as Mr. Washington testified in that hearing almost a year ago, it was a pharmacy back then that happened to sell alcohol. At some point thereafter, in the late 1960s, early 1970s, it went over to selling nothing but alcohol. And at that time, the community didn't object to the changed nature of the business. So in this case, with this transfer, there was no request to change the nature of the business, to expand it and make it a two-story liquor store, or double the square footage of the establishment, make it a mega liquor store. It was simply to continue its existing use with new owners who the community admittedly did not, didn't have any specific objections about. And Mr. Washington's testimony was very clear, and the agreement, the MOU, the proposed MOU was very clear. The biggest part of it, other than the usual parts of keep your place clean and obey all laws and have share phone numbers so that we have a line of communication. But first thing that Mr. Washington said and that others said was that we have security concerns in the area because of the type of violent crime that has occurred. We have asked for additional security measures, and these security measures include video surveillance with PTC, pan, tilt, and zoom. Mr. Blair from CSAFE generally testified to the idea that the neighborhood, that liquor stores are a magnet for criminal activity. Once again, what do we take out of that? Safety, not necessarily public need and desire. Mr. Blair was appearing in a professional role, certainly not as a member of the public. Mr. Blair's objection then was with general safety for a liquor establishment. The same went for Mr. Vaughn, who indicated in his testimony, And where's Mr. Vaughn? Thank you. No, I'm sorry, I meant Mr. Fisher. Mr. Ulysses Fisher. He testified that we're trying to heal this community, and we can't heal the community if this establishment is allowed to continue to go on the way it is. And then later, he says that the owner is not responsible for the crime there, but this establishment breeds this lifestyle. Once again, the board doesn't see that as an opinion on public need and desire, but sees it as a cry and a concern about safety and crime. Uses the word heal, uses the word crime, uses the word breeds. It's clear that the concerns on the record are about safety and not about public desire. And the board is going to amend its findings for March 1st, 2012, after having the benefit of going through a transcript and instead of going through a hearing in real time with objections. And we are going to determine that there is no evidence on the record against the public need and desire, but against the safety concerns, that these are not desire-based statements. These are statements based all about safety, health, and welfare of the neighborhood, rather than specific instances of transgressions. The board is not a social planning agency. The city council determines land use and determines whether or not to allow a certain location to be used a certain way. This establishment or this address has housed a Class A or its predecessor liquor license for 77 years before today. 77 years with competition, as Mr. Washington would readily admit. That this is not the only liquor store in the Coldstream, Homestead, Montebello area. That's not why it's been open for 77 years. It has competitors, and it's still around 77 years later. And the board believes that that in and of itself is one factor of public need and desire. So all of that having been said, the board, believe it or not, was actually trying to help the protestants in this matter, because for 77 years prior, there's never been any security cameras or any security plan at this location. The applicant's lawyer refused to sign an MOU mandating that they had to do that. So the board clearly saw that we have security issues, safety, 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 crime, crime, crime. That's all we heard from the witnesses. So the board said, and tried not to surprise anybody, at the very end of the hearing, the board made it so clear, and somehow the board feels that got tossed away. It got tossed to the wayside when emails went out to community associations and when the Community Law Center sent out an email. And all of a sudden we started getting emails, the board started getting emails about how we violated your due process, the community's due process. When the board made it so clear at the very end of the case that we have an open mind if we could get a security plan. The same security plan that the community was not able to procure by voluntary agreement with the licensee. So the board made it clear that that's what we're looking for here. And if we weren't clear, we thought we gave a very explicit hint as to what we needed and to what was good enough for us to feel comfortable that the community would be safer. Rather than have a perfect applicant, the community instead would be getting a licensee who now had a security plan, who now was able to monitor, as you saw today, 4 different angles of his business while he's standing here in City Hall. It was simply our desire to allow for, to require, if by strong arm, the applicants to enter into a security plan, to come up with some kind of security plan. And in fact, they bit. They took the bait. They understood what we needed, what they hadn't done, and then they went and brought it to us. and said, we'll do it. And the board, surprising no one but perhaps you or the Community Law Center, the board did it. Or Councilwoman Clark, for that matter. The board, in fact, said yes, just like we said. We'll have an open mind. Now they've got a security plan. Now we're going to let it go. We're going to let it go because our concerns about crime, safety, health, and welfare have now been met. And so that was the reason that we denied the requests before, despite what we said in the record about public need and desire. We denied it, it's clear, based on the fact that there were crime, safety, and health concerns. Crime, safety, and health concerns that the board determined were abated by the inclusion of a security plan into the licensee's request. And so the board held a hearing on reconsideration and granted it. And then we were accused of having done an end around and not having been communicative with anyone, where we made it so clear on March 1st what we wanted. And in fact, on March 6th, we got a proposal 5 days later. So the board takes it personally when you tell us that we've violated your due process in this matter, because we absolutely feel that we did everything above board. We made it obvious what we needed. We were simply trying to implement at least some portion of that in Show 8 unborn MOU, the one that never got signed. We thought if we could take what we thought, based on the testimony, was the most important part of that MOU, and we could get them to agree to it, that would be something. And we understand that the community, that the protestants may disagree with us in that regard. But the board was simply trying to help, and we don't apologize for that. But everything we did above board. All of that having been said, the board's review of the transcript of March 1st indicates very clearly that our concerns were based on public safety, health, and welfare. And that is the reason, despite the fact that we mentioned public need and desire in that time, that was not the overriding factor, the factor that caused us to deny this transfer. The factor was the concerns regarding the safety and welfare of the community. For those reasons, the board determines, after a review of the transcript, after a review of the judge's order, her oral opinion, the case law regarding Country Ridge Shopping Center, and most importantly, the security plan. The board feels that any objections that we had to the transfer, based on our hearing of March 1st, have been overridden. They have satisfied the requirements under the provision of 10202A relating to public safety, health, and welfare. So once again, the board went through the transcript and doesn't see petitions, doesn't see anything other than testimony about safety concerns. It's all about safety. It's clear that that was the crux of the case. Those concerns the board tried to ameliorate with the inclusion of the security plan, and we determined that they have been met. And the board is satisfied under Article 10202A that the factors have been met. Thank you very much. We're off the record.